911 on location of your emergency.
Hi, something is happening. Something's happened in our house. We don't know what.
It's been more than 900 days since 4 University of Idaho students were stabbed to death. For their families, an agonizing wait for justice.
You just keep having to relive it over and over and over until, it gets itself through the process.
The trial of suspect Bryan Kohberger is quickly approaching, with defense motions coming fast and furious.
It's been impressive, to say the least, the effort that they've expended in challenging each and every aspect of this case.
A death penalty case that could land before the Supreme Court as this true crime saga unfolds in real time.
This could happen to anybody, and that's the fascination and what's going on with this guy in his head. And he's an odd duck.
As a theory on the motive emerges, we're going inside the Idaho murders tonight in the Spotlight.
The Spotlight brought to you by Beacon Plumbing.
Good evening, I'm David Rose, and thank you for joining us for this special edition of The Spotlight and the next installment of Bryan Kohberger inside the Idaho murders. Kohberger is accused of killing 4 University of Idaho students in the early morning hours of November 13th, 2022. Ethan Chapin, Kaylee Gonsalves, Madison Mogan, and Xana Kernodle found stabbed to death in their off-campus home in Moscow, Idaho, less than 10 miles from the Washington State University campus in Pullman, where Kohberger was a graduate student in criminology. 2.5 years later, the motive remains a haunting question. Now a new theory is being floated. Writer Howard Bloom recently posted an article on Airmail suggesting that prosecutors believe Kohberger committed the murders to impress his former professor. That professor is Katherine Ramsland, a renowned forensic psychologist and author of more than 50 books, who taught Kohberger at DeSales University in Pennsylvania. In his article, Bloom writes, quote, Kohberger wanted to prove that the pupil was ready to become the teacher. He'd kill and get away with it. He'd prove how smart he was. Bloom compares Kohberger to John Hinckley, who tried to assassinate Ronald Reagan to impress actress Jodie Foster. The article suggests Ramsland stayed in touch with Kohberger since he left DeSales. But in a statement to News Nation, Ramsland firmly denies key claims made in the article, saying she had no correspondence with Kohberger while he was at WSU and has not been in contact with him since his arrest. I spoke with retired homicide detective Cloyd Steiger about this new theory and how important a motive is in the case against Kohberger.
You don't have to show motive in any trial. You just have to show that it happened. If you have a motive, that's a bonus, but you don't ever have to show motive.
Is it possible he was trying to impress her?
Maybe. I don't know. Who knows what's in his warped mind, but yeah. I know Katherine Ramsland, by the way. She's a friend. She would do nothing like that.
On social media, Bloom responded to Ramsland's statement, at one point apologizing for stating in error that Kohberger emailed her while at WSU. Bloom ended the post by saying he stands by his hypothesis as just that, a theory. It remains to be seen whether prosecutors will introduce a motive once Kohberger goes on trial. That's set to begin August 11th. In this pretrial phase, we've been following a flurry of big developments. That includes 2 attempts by the defense to get the death penalty taken off the table. The judge in this case knocking down both of those motions. The judge deciding that Kohberger's autism diagnosis does not meet the legal definition of an intellectual disability that could spare him from the death penalty if convicted. The defense has been arguing that it would be unconstitutional or cruel and unusual punishment to send Kohberger to the firing squad if he's found guilty. Kohberger's lawyers told Ada County Judge Stephen Hippler that Kohberger's autism diagnosis means he can't fully contribute to his own defense. This despite his advanced degrees and high IQ.
They're not saying, look, he can't be found guilty of murder. He can, just like somebody with intellectual disability can be found guilty of murder. But because of this severe developmental disorder, he doesn't have sufficient moral culpability to justify putting him to death.
Since so few capital murder cases have considered whether autism was a factor, Cornell University law professor John Bloom says the defeat of this defense motion might give Kohberger's team its strongest chance for an appeal, one that could reach all the way to the U.S. Supreme Court.
I think there's an opportunity for a court to say, either as a matter of state law, state constitutional law, federal law, that we're not going to allow people with autism to be sentenced to death.
To unpack this defense motion and the judge's ruling, we spoke with noted attorney Ann Brimner.
Well, the defense tried to strike the death penalty, saying that because he's been diagnosed with autism, then there shouldn't be, the death penalty phase should not be allowed, and he shouldn't be subject to the death penalty. They're basically saying there's a case in 2000 U.S. Supreme Court that said you cannot execute somebody. It's cruel and unusual punishment under the 8th Amendment to execute somebody based on if they're mentally ill. I mean, overall, I mean, there can be different aspects of that, but overall, you can't have somebody, they call it intellectual disability is the terminology. It's cruel and unusual to execute somebody that has that type of a situation. So what they tried to say, the defense tried to say, is autism fits in that category. Therefore, judge, you need to strike the death penalty because you'd be violating the 8th Amendment to even subject him to it. Judge comes back and says it's not an intellectual disability that would qualify for striking the death penalty, but it could be used in mitigation in the defense portion of the penalty phase if it comes to that. So during that phase, you can raise all kinds of different things, including that he has autism. But it's not enough to strike the death penalty. They've really tried hard with that. And by the way, it looks like the state's asking for some more psych testing right now. I don't know if it's related to that and the judge's comment about it being available during the penalty phase. It may be that's why they're asking for more testing. But the fact remains is that's just not going to be enough to strike the death penalty. I don't know if they were banking on that or not, but that they sure tried hard, because the win for someone in a case like this defending is to get the death penalty off the table.
Some have questioned whether Kohberger could use an insanity defense in his case. The short answer is no, you can't in Idaho. As the Spotlight's Shira Matsuzawa reports, it's one of 4 states that does not have an insanity defense.
Back in the 1970s, early 80s, we found that the insanity defense was being misused in Idaho, in my opinion, in drunk driving cases, in minor matters. Someone would assert that they did not know the nature and quality of their act.
Which is why former Idaho Attorney General, as well as Lieutenant Governor and current criminal defense attorney Dave Leroy, pushed for the state to repeal it. He says what would often happen is both sides would get their own psychiatrist or psychologist, which would often confuse the jury and leave taxpayers footing the bill on all of the cases and expenses.
I think it, over time, has probably saved the taxpayers of the state of Idaho potentially hundreds of thousands or even millions of dollars.
While there isn't an insanity defense in Idaho, a person's mental state is still taken into consideration before and after their trial.
We still, before a trial is had, if someone is so out of touch with reality that they can't aid in their own defense, have the ability to put someone in a mental health secure setting to try to improve their mental health to the point that they can go forward to trial. So if someone is not fit for trial, we don't try them as a criminal defendant.
In Bryan Kohberger's case, he has not been deemed mentally incompetent to stand trial. His defense, however, has previously asked the judge to remove the death penalty, claiming executing someone with autism would constitute as cruel and unusual punishment. The judge issued a written ruling that said, in part, not only has the defendant failed to show that autism spectrum disorder is equivalent to an intellectual disability for death penalty exemption purposes, he has not shown there is national consensus against subjecting individuals with ASD to capital punishment. He went on to write, ASD may be a mitigating factor to be weighed against the aggravating factors in determining if the defendant should receive the death penalty, but it is not a death penalty disqualifier. Kohberger is charged in the murders of Ethan Chapin, Xana Coronado, Kaylee Gonzalez, and Madison Mogan. If he is found guilty, the court can consider his mental state when determining his sentence. Earlier this year, Kohberger's medical and mental health records were handed over to prosecutors. The contents remain confidential, but some experts say those records could be used as a potential mitigating factor that spares his life if he is sentenced to the death penalty.
We don't disregard or pretend that people with mental illness don't commit crimes. We simply don't allow them to avoid conviction for a crime. And we deal with the mental health issues before or afterward in appropriate ways.
For the Spotlight, I'm Shira Matsuzawa.
As mentioned earlier, Kohberger's attorneys tried to take the death penalty off the table in 2 different ways. Less than a week after the ruling on Kohberger's autism diagnosis, the judge also denied a defense motion to strike the death penalty based on allegations that the prosecution failed to turn over evidence on time. Defense attorneys argue that delays in the discovery process hindered their ability to mount a complete defense for Kohberger, pointing to the fact that it was over 50 terabytes of data. The judge disagreed, writing in a court order that while the discovery is lengthy, the manner in which the state produced it did not constitute misconduct. In that order, the judge said the defense complaints, quote, ring hollow. That ruling stands in contrast to a decision made in another high-profile case out of Idaho. Ann Bremner weighs in on that.
Well, yeah, I mean, I saw this one coming from Lori Daybell's case, the cult mom, because she, like we talked about, shortly before the trial said, the state has not given me all the discovery I requested. They haven't complied with the rules in terms of giving me enough information to adequately prepare for trial. It's a due process violation. I can't prepare. And guess what the judge did? The judge agreed. And as a sanction for not complying with discovery, he struck the death penalty. So it's almost like looking at the same playbook here. But they've been raising it for a while. And they are on the eve of trial. And so as they finally raise it to the judge, he says, he used the word hollow, that their claims really were hollow in terms of saying they don't have enough information. Because he saw this coming. You know, he saw them talking about it, and he's in Idaho and knows about Lori Daybell's, the ruling there striking the death penalty. So they said it's disorganized. There's stuff in there that's not material, that you know, they've basically just thrown a bunch of information at us, and it's too hard for us to go through all of it and get ready for trial. And Ann Taylor said, I personally review everything in a case. I don't rely on summaries or AI or interns or anything else. I read everything. I'm not ready. The judge said hollow, and the judge said, you have not shown me that you've tried to hire staff, that you've tried to have people, you know, help you, that you've tried to organize this with certain programs. You haven't shown any of that. And so I'm going to deny your motion to, you know, for any kind of a sanction and striking the death penalty. So they could have come in a little bit more well-armed, shall we say, on that issue. And the judge denied their motion.
So, with the death penalty still on the table, the question becomes, what will Kohberger's attorneys try next? The defense is expected to suggest that there was a second suspect, but retired Detective Steiger tells me it won't make a difference.
There could be a second suspect, but that doesn't exonerate the first suspect. I don't think there was a second suspect, and they have to show to the court reasonable grounds to bring that up before the judge will allow it.
They can't just spring that on the jury in the middle of the trial.
No. It's just an attempt to muddy the water.
Yeah, and that seems to be what the defense is doing a lot.
That's all they can do. I used to call it, when you have a case where it's just overwhelming, the defense attorneys do what I used to call the squid defense. They squirt out ink in the water and try to swim away in the confusion, right? That's what they're doing here.
So this case is kind of like taming a horse, right? Just when you think you got him walking well, you get bucked right off the horse.
Well, this is a high-stakes trial, a high-stakes case, so it's going to happen. And the prosecutors, I would hope, are ready for all of this.
Recent court filings in the Bryan Kohberger case revealed this selfie. It was taken on Kohberger's phone on November 13th, 2022, just hours after the brutal murders of the 4 University of Idaho students.
I see a cocky guy, and who knows why do you normally, when you get up, you're home alone, take a shower, you take a selfie? What was the purpose of that? To show you're home? I mean, maybe he thought that would be evidence that he was home. But it's fine, you were home at 9:30 in the morning, that doesn't mean anything.
We can expect to see that selfie during Kohberger's trial this summer, and it could prove a damning piece of evidence against him.
I thought that's quote-unquote selfie picture, I thought was very damaging for the defense for a number of reasons. A, it was the same day, within hours of the offenses. B, he was in front of a shower without the shower curtain. I think that was found somewhere else. And it looks like he just took a shower and he had his shirt all buttoned up, you know, to the top. It looked like to me like there were some injuries. I think some people saw that, some didn't, but it looked like on his forehead to me, and on his hand and knuckles, like he had some bruising. Maybe it's just the lighting. But the worst part was the thumbs up. I mean, that just said, you know, mission accomplished to me. And it was so creepy. And he looks creepy. He looks like really kind of pale and kind of greasy, and his eyes look kind of dead. And it's like you just put that picture up there in your opening statement, and then everyone on the jury is like, ugh, you know, like, but this thing, you know, like I did it. And I don't know what that's all about, but he took that picture of himself, and it was in his phone. And obviously, to him, that was the mission accomplished. So I think it's almost as damaging as the buying the Amazon knife. It's up there because it shows that's what he meant to do, and he did it. He meant to kill those people. You know, he meant to just do, you know, mayhem in terms of a crime scene. And he drove there from, you know, from Wazoo, from his apartment, and in Pullman, and he came back home, and I bet that's the first thing he did, is take a shower. He had to have had blood on him. That's been an issue in the case too, how much blood was on him. But he took a shower, and then he did the thumbs up to himself, you know, like, nice job, well done.
On the night that Ethan Chapin, Kaylee Gonsalves, Madison Mogan, and Xana Kernodle were murdered, a surviving roommate witnessed a masked intruder in their home and described him to police as having bushy eyebrows. The defense filed a motion trying to get that description blocked from the trial, claiming the witness was drunk. I asked retired homicide detective Cloyd Steiger about the importance of this bushy eyebrow debate.
I would say it's only somewhat important. I mean, like I said, of all the things that's going against him, that's the least of their worries. But you know, it doesn't matter if you're drunk. I mean, if you're not slobbering on the floor, almost unconscious drunk, 60% of the homicides they investigated had drunk witnesses, right? So it's a matter of quantification. You can't quantify that talking, but you know, the fact that she brought it up several times, because when she saw him going through there, it was a significant event for her. It's not like you're just walking down the street and you pass somebody and somebody says later, hey, what'd that guy look like you passed? Well, I don't know, I didn't pay attention to him. There was a significant event, and that's what she noticed, and she continually brought, the only thing that was visible, because he had a mask on, was his eyes, and hey, so that's completely credible to me.
Well, the judge denied the defense motion, saying the eyewitness testimony is highly relevant in this case. Attorney Ann Bremner calling that motion thin and convoluted. Here's her take on why the defense has filed so many motions trying to throw out evidence.
Well, they're losing, but they're expecting to lose. And so they're basically preserving things on appeal, because it'll be an automatic appeal if the death penalty is imposed. So they want to have everything on the record that they can raise later with the court on the appeal. So they didn't expect to win most of those, but they sure made those motions. And remember all the DNA motions and search warrant challenges and arrest warrant challenge and all of that, challenging the DNA on the basis of the analysis. They've done all of that. So they're hopeful, you know, that something in that, you know, might result in a reversal.
I feel for the people who are going to wind up sitting on this jury. It's not going to be an easy task, but it's an important one.
12 jurors and 6 alternates will be tasked with deciding the guilt or innocence of Bryan Kohberger. Choosing that panel is a high-stakes process for the prosecution and defense. The Spotlight's Shira Matsuzawa spoke with legal experts about what both sides will be looking for when jury selection begins.
It's your civic responsibility serving on a jury.
One of the best things about America is our jury system.
And while it's unknown who will serve on the jury for Bryan Kohberger's trial, both sides are gearing up for the jury selection process.
For me, it's like my favorite part of a case, because I get a really good sense of who I'll be together with, you know, for the ensuing weeks or months.
Attorney Ann Bremner says before potential jurors set foot into the courthouse, they'll likely fill out a lengthy questionnaire, asking them their views on law enforcement, the death penalty, and if they've ever heard of Bryan Kohberger. From there, attorneys can question the prospective jurors in a process known as voir dire.
And then you start looking at 2 things. One is indoctrination, and the other is kind of exploration. And indoctrination during a jury selection is to try and hit your themes as you talk to jurors. You know, like whatever the themes are for each side, to say, do you agree with this idea? how do you feel about this or that? You know, to try and get people kind of going away a little bit then. And a lot of judges won't allow that, but that's something you try to do.
Dr. Andrea Blunt-Hunter is a trial consultant with Mind Matters Jury Consulting. She says they're not looking for a juror who has never heard of Kohberger and how he's accused of murdering University of Idaho students Kaylee Gonzalez, Madison Mogan, Ethan Chapin, and Xana Kernodle, because that could be difficult considering the media exposure this case has received. But rather they're looking for a person in the middle.
Those who've heard about it, but understands there's always two sides to a story, and the best case for the defense is just to find someone who's willing to hear their story.
Both sides are also paying attention to demographics as well as personalities.
Each side will be looking for different relationships people have to authority. For example, the prosecution would want law and order advocates on their side, and there's probably a lot of them in Boise, Idaho. So the defense has a tougher challenge.
She says Kohberger's attorneys will be looking for people who are more skeptical and don't accept things at first glance. There's also another challenge.
One of the dark horses that both sides are afraid of is the juror who really wants to be on this jury.
And she says no one wants that person to slip through because it could lead to a mistrial. For the Spotlight, I'm Shira Matsuzawa.
Jury selection is set to begin on July 30th, with the trial scheduled to start on August 11th. And you can count on Fox 13 for coverage every step of the way, with episode 5 of Bryan Kohberger, Inside the Idaho Murders, coming next month. And you can stream the whole series so far on the Fox Local app.